Bună dimineața. And that's the end of my Romanian. First, I'd like to thank Freedom House for giving me the opportunity to share thoughts and ideas about asset recovery. A little bit about my background. I've been a prosecutor from the day I graduated from law school. I prosecuted in the Army for 4 years, then I was a prosecutor in the state of California in the United States. And for the last 22 years, I've been a prosecutor specialized in asset recovery in the Southern District of Florida, Miami, West Palm Beach. And I can tell you that I've seen the program grow, and that if you can get your program going, it is a wonderful tool to fight crime by just taking the ill-gotten gains and turning it around and reinvesting it in the effort to catch the criminal. And it just continues to grow and grow and grow. At this point in time, our program, we have over $4 billion in the asset forfeiture fund that has been deposited from our cases. This is an example of the first that I could find of non-conviction based forfeiture going back to biblical times, where there was no conviction but the state forfeited an ox. So non-conviction based asset forfeiture has a very long history. In the United States, our program began as a non-conviction based forfeiture program, and it was based on our customs statutes, and it was used at the very beginning of our country to combat piracy. It was a way that we could forfeit pirate ships, even though we may not have caught the pirates, and then put them into use with our navies. It was non-conviction based, and as mentioned earlier, the process is what's called an in rem process. In other words, it is against the asset itself, not against an individual. So in the United States, you will see cases where the name of our case when we file it is the United States versus one helicopter, the United States versus a Lamborghini, the United States versus cattle. Whatever it is we're seeking, it'll be the United States against that piece of property. It wasn't until 1978 that we began to, and we created the statutes to do criminal forfeiture, so that as we were doing a prosecution against a criminal, we could also add in forfeiture to seek the ill-gotten gains of the criminal. We did that because we were suffering greatly trying to fight the drug trade, especially in Miami, where I was hired to get involved in the forfeitures. The millions and millions and millions of dollars that were traveling through, we determined, based on our experience, one of the best ways to fight and dismember these organizations that were bringing in drugs was to take away the money that they were in the business for in the first place. In 1984, we amended our statutes to include real property so that we could go after the large mansions, not just the bank accounts, and trace the money into any other assets, racehorses, fast motorboats, wherever the money had gone, we could then seek it. But we also wanted to focus especially on real property because it's a little bit more complicated. In the United States, we have basically 3 types of forfeitures. We have what is called administrative forfeiture, in which our legislatures have allowed our various police agencies to do what is an administrative forfeiture. For example, Drug Administration, the DEA, they can do administrative forfeitures. They cannot do it against real property, but they can take large amounts of money in the millions and do an administrative forfeiture. Now, the limitation on that is that if someone files a claim on that property, then they must immediately stop the forfeiture and they must turn it over to the judicial process. Now, we have the criminal judicial process in which we have indicted an individual with a crime. At the same time, we will include in the indictment a count forfeiting his assets. It is a two-stage process. The first stage in the criminal is that we have to convict the criminal of the crime. He then has an opportunity to also fight the forfeiture. He has the opportunity to do it in front of the judge, or he has the opportunity to do it in front of the jury. Typically, in 90+% of the cases, after he's been convicted, he does not want to fight the forfeiture anymore and gives up. It's at that point that we begin what we call ancillary proceedings, and that is where we forfeit the property against the rest of the world. In our civil cases, as I mentioned, it is in rem against the assets only. And the assets, in order to start a civil case, the assets must be involved in the criminal activity in one way, either facilitating the crime as an instrumentality or as the proceeds of crime. This is a chart showing, in a nutshell, how our system works. You can see that it breaks into the two types, the administrative forfeiture, which is done by the agencies, and you'll note that once the claim is filed, it is then forced to go back to the judicial system within 90 days. So that is how the individuals are protected under an administrative forfeiture. Under the judicial forfeiture, it then breaks into whether we want to bring a civil forfeiture, which is it's kind of a hybrid in the United States. We refer to it as quasi-criminal because it's in between a civil case and a full criminal case where we're going to actually convict someone and send them to jail. As I said earlier, in a criminal forfeiture, we must first convict. It's after the guilt phase. And after the defendant has lost his interest in the property, then we begin the ancillary proceedings, and it becomes also like a civil case. The rules of civil procedure are followed, which means the individuals must answer many more questions and respond to our discovery requests in many more ways because they do not have the Fifth Amendment right against self-incrimination in this stage, because the defendant's been convicted and these are third parties that do not have that right, or if they do intend to use that right and they do refuse to answer questions, then we are entitled to a presumption that their answer would have been what we want, that they had. For example, I would ask a question, is it not true that this is a proceed of a drug trial? If a claimant in the ancillary proceeding were to say, I am not going to answer that because it might incriminate me, the court would then presume that the answer was yes. The level of proof, unlike to convict, which is beyond a reasonable doubt, is by a preponderance of the evidence. This is a diagram. As you can tell, I've given presentations in Mexico and other Spanish-speaking countries. So I apologize that I did not have time to have this translated into Romanian. But it helps me to understand and explain our levels of proof. And of course, it starts with no evidence at all. And then we have what's called probable cause, which is the level of proof that we have to present to our magistrates in order to either get a search warrant or to get a seizure warrant to go out and seize assets. Once we get to the forfeiture trial stage, either in the ancillary proceeding, which is the criminal, or in a separate civil forfeiture action, then the standard of proof is by a preponderance of the evidence. In other words, we have to prove just a little bit, just a slight bit more than it's a 50-50 call for the judge whether it should be forfeited or not. We just need a very small, little extra piece of evidence. And then, of course, we have beyond a reasonable doubt, which is our highest standard, which is for convicting the defendants. And then, of course, 100%, no human can know. One of the big advantages that we have in taking a case criminally is that we can seek assets that were not involved in the criminal activity. So, for example, if we were to convict a drug trafficker and to prove that he had done $1 million worth of trafficking and sale of drugs, and we only found $100,000 in his bank account, we can also seek what we call a money judgment for the $1 million. And we will get an order from the court forfeiting $1 million, even though we don't have that money. We're then allowed to find out any other assets that this defendant may have. It may be a house or something that he owned before he got involved in drug trafficking. It may be an inheritance that has nothing to do with drug trafficking. And we are entitled to substitute that asset into the forfeiture. So we file a motion before our courts to substitute. It is substituted in, we can then forfeit it, and the defendant is given a credit for the value of that asset against the $1 million judgment. So let's say that he had $10 million that he had inherited, we would be limited to, in the case that I gave you where we already had $100,000, to $900,000 worth of value. Now, we could seize like a $10 million mansion and force him to sell it, and then we would give him back the excess that we could not prove was involved in any criminal activity. So our process in the criminal side, we have a forfeiture with an indictment in it. We either have a plea or a trial. In our system, we have the ability to make agreements with the defendants, and in return for a reduced sentence, they agree to admit their guilt. Our system, because we have a lot of cases, in my opinion, would collapse if we didn't have this ability to take these plea agreements, because if we had to go to trial on every single case that we're handling, the courts would collapse and we would, because there's just too many, and we just would never be able to do it. So I would say, and Jay can probably help me with it, but probably about 90% of our cases end up in pleas, and only about 10% actually go to a trial. Once you get through all the determination of the defendant's guilt, then we have either the jury or the court determines whether or not the property should be forfeited. If it says no, then of course it doesn't. But if his interest is forfeited, then we start, as I mentioned, the ancillary proceeding. The judge enters a preliminary order of forfeiture, which says the defendant has now lost all of his interests. And in that order, it'll say to the prosecutor, now you must find everyone that you must do due diligence to find everyone that may have an interest in this property. You must provide them with personal notice. You must publish this, that you are going to seek forfeiture of all this property. And that we do by, we have a website on the internet called forfeiture.gov, in which we publish all of the assets that we are seeking to forfeit throughout the United States. If an individual comes forward and says, that property actually belonged to me and I'm innocent, then we begin the ancillary process. This is a process where we are allowed to do civil rules of discovery. We are allowed to take depositions. We are allowed to send interrogatories. We are allowed to subpoena records. We have much broader powers in seeking evidence against any of these claimants. At the end of that process, the court then will have a hearing in front of the court only, but it'll be there'll be no jury, but it'll be a presentation of witnesses, presentation of evidence by the prosecutor and then by the claimant to try and rebut what we're talking about. Now, the burden of proof, because it's already been determined that this property is involved in criminal activity, the burden of proof is upon the claimant. So the claimant first must come forward, and he must show that he is innocent. Then the burden would shift, assuming he met that burden by a preponderance of the evidence. Then the prosecutor would have to prove, and then from there forward we would move, assuming that we're successful, we would go to a final order of forfeiture, and then victims would have their money returned, and if it was an international case, there would be international sharing, and if it's a local case where we're working on a task force with our local police departments, we would then share with the local police departments. Civil forfeiture, as I mentioned earlier, is quasi-criminal in nature. It's not a true civil case. Our true civil cases are normally contract cases, or they could be cases based on negligence, or one citizen hurt another citizen and they're trying to recover. That's a typical civil case. Asset forfeiture civil cases, while we call them civil, they're really quasi-criminal, and the courts have even said that in their opinion, that this is a quasi-criminal proceeding. It's not truly civil in nature. And that's because, one, in order to initiate our cases, they have to be based upon a criminal code. We have to show that that this property was either the proceeds or an instrumentality in a crime upon which forfeiture is authorized. We also use the law of the sea, because our development was from 1789 and this piracy. We use what the admiralty laws in our country when we're determining how to seize assets, who can manage those assets, and how we can sell those assets. As I mentioned earlier, it's MREM. It's only against the assets. No persons are involved. It can lead to a criminal case, and that has happened to me on numerous occasions because we have the power to go much deeper in our discovery process. Oftentimes, we can get additional evidence that we didn't have before. We were unable to prosecute criminally, but when we take sworn statements and we take the sworn depositions, admissions are made during those long interviews that can then be used in a criminal case and can initiate a criminal action against the person who is claiming the property. As I mentioned, though, only the assets involved in criminal activity. There are no, so unlike the criminal case where we can substitute in properties not involved in the crime. In our civil forfeiture cases, we cannot do that. We are not allowed to do that. By the same token, we don't have to demonstrate that any one individual committed the crime. All we have to show is that the property was involved in a crime. We don't have to prove the person who committed the crime, just that it was involved in the crime, in criminal activity. And one of the most important features for us is that we can also proceed against fugitives. So, for example, in a case that Norman Hilton, the marshal here, and I worked on, we had a criminal case. They escaped to Cuba. We couldn't, once they escaped, the criminal process stops because they're fugitives. We cannot proceed until they're brought back and in our jurisdiction and under our custody. So at that point, the criminal forfeiture stopped. We then initiated a civil forfeiture action because we could prove that various properties were involved in criminal activity. And we were able to proceed, seek final orders of forfeiture in the United States. We located the properties in the Dominican Republic, and through the Palermo Convention, we went to the Dominican Republic, asked them to ratify our orders, which they took through their court system, and their court system issued a homologación, a ratification saying that our order from the United States now has the same power as an order from their court. And once we did that, then we proceeded to start selling properties, and I think we're at 5 million higher. He's throwing his thumb up. 5, maybe $10 million now that we found and forfeited in the Dominican Republic using the civil forfeiture law. So here's the diagram of the civil forfeiture. Once we determine that a property is involved in criminal activity, we file a civil complaint. We are required to send notice. We not only do we publish it again to the world on the internet, but we also have to again we have to use due diligence to find the individuals involved and serve it on them. In this case that I was speaking of, the individuals had escaped to Cuba, and we, by using the Swiss embassy and by using our mission there, they were in jail because they had violated Cuban law as well by leaving the country for more than a year and trying to sneak back in. We were able to find them in jail and send a representative in and physically put notice in their hands. So we notified them. That's the kind of level we'll go to, because our Constitution requires us to do that, because every citizen is entitled to due process of law. We then, if there's a valid claim, we will start this whole discovery process, filing motions, and the burden of proof. The original burden of proof, in this case, starts on the government, because we have to show that this property is either proceeds of a crime or it's an instrumentality of the crime. It was something that was used to facilitate a crime. Once we've done that, then the burden shifts, as it did in the criminal case, to the claimant, who then must prove that they are innocent owners. And I'll get into a little more detail of that later, and then eventually we end up with a final order of forfeiture. These are the kind of cases, of course, drug trafficking, terrorism, public corruption, fraud, human trafficking, and numerous others. Almost all federal crimes in the United States have a forfeiture component to which we can use to forfeit properties. How do we protect the interests of innocent third parties? Well, as I mentioned earlier, due process under our Constitution requires notices, and the judges hold us to a high standard to make sure that every potential claimant is given notice which tells him, we are seeking the forfeiture of this property. This is how you have to make a claim. This is where you need to make a claim, and this is the time you have to do it. You must file your claim by, and it'll have a specific date. It's normally 30 days, but oftentimes it's increased to 60 days. And as prosecutors, we typically are fairly liberal in allowing claims to be filed even a little bit late, just because we don't want to challenge that right to due process and take the property without that person having their opportunity to have a day in court. Then we also have what are the innocent ownership defenses. Now, the innocent ownership defense, our notice is, well, going back to the notice, when we do an administrative forfeiture, the police agencies have 60 days from the date that they seize the property to get notice to claimants. If they miss that date, then they're required to return the property. In criminal, we have 30 days after the preliminary order of forfeiture is entered. And in our civil non-conviction based, we must serve parties within 90 days after we have filed that civil complaint. What is the defense in the administrative? You just file a claim. If you file a claim, it automatically stops the forfeiture process and forces it to be sent to the prosecutor's office to determine if we're going to do a non-conviction-based forfeiture. And I would say we probably file about 70%, but there are a significant amount of cases that we look at and we decide, no, there's insufficient evidence, we're not going to proceed, and the property is returned. And then we have our civil innocent ownership defenses and our criminal innocent ownership defenses. As I had said, after the conviction and forfeiture of the defendant's rights, we begin the ancillary process. If there is no conviction, then there is no forfeiture and all property is returned. The preliminary order issues and the third parties may file a claim. No claim can be filed prior to the conviction. So if we have, for example, a house that we're seeking to forfeit and there is a mortgage on that property and it's an innocent bank, they cannot interfere with our criminal prosecution. They have to wait. They're precluded by law from interfering with our criminal prosecution. Once the conviction is obtained, then they're entitled to file their claims and seek recompense. The burden of proof, as we mentioned earlier, shifts to that person to prove that they are innocent owners. This is our statute. It's in the materials. It's basically a two-part, and I'm just going to move through that quickly because it's a lot to read. It's basically a two-part system. Before the crime occurred and after the crime occurred. If the claimant obtained their rights before the crime occurred and they have a superior right to that property, to the defendant, then they will be successful in returning their property. The example I gave before is the mortgage company who has a mortgage on the property. They have an absolute right to be recompensed for the money that they loaned on that property. Their right is superior to the defendant because if the defendant stopped paying, they can move and foreclose on the property. So that would be one that we would immediately accept. And in fact, sometimes we'll even move early on to contact them and let them know that we are not going to fight them on that because we don't want to get attorney's fees involved from them because we know that they're innocent, and we tell them that, and we even enter agreements where we tell them, you will be innocent, do not spend a lot of time on attorneys so that we don't have to necessarily fight you about paying for the attorney's fees. After the crime, we have two possible defenses. Either a bona fide purchaser for value, in other words, an individual that paid, okay. Okay, that's sore. I was worried about that. Okay, someone who's paid real money and they have no knowledge of what's happening, and without reasonable cause. That's the second part of after. Let me move quickly through this. Similarly, we have a civil ownership defense. Burden shifts to the defendant to show. We look again to when the claim is filed. This is the statute. It's similar to the criminal superior right, but you must show without knowledge of the crime, or in this sense, it's a little bit different. If you had knowledge of the crime, you must and you can establish as a claimant that you took all reasonable steps to stop the illegal use of your property. And my last trial I tried, we got past all of the issues of the forfeitability. The one issue was whether or not the claimant had done all things reasonable to try and stop the illegal activity. We took that to a jury. The issue in a nutshell in 1 minute was it was a drug area where they were selling drugs. The owner had nothing to do with the drugs, tried to stop the drug trafficking, met with the police. It continued to go on and on. The police said you needed to do 3 things: put lights up, put signs up, and hire a security guard. He put lights up, he put signs up, but he hired an 85-year-old man as his security guard. When we spoke with the 85-year-old man and asked him what he did to stop the drug trafficking, he said, "I told the drug traffickers to stop." And then when we asked him, and what happened next, he said, "They told me they would kill me if I didn't shut up and leave." And then I asked him, "What did you do next?" "I would shut up and leave." I said, "Did you call the police?" "No, because they would kill me." So I shut up and left. We presented that to the jury. The jury found that they hadn't taken all reasonable steps, that I had witnesses from the police come in and testify that that trafficking would have stopped immediately if they had hired an off-duty police officer or a regular security guard. So the jury found, no, that was insufficient, and the property was forfeited. Okay. Okay. With that, I'll stop. I'm over my time.
Thank you very much, Sam. And I would like to thank you very much for delaying your departure so that you can be present here today. Thank you.